Hi, this is Kurt Barone, and welcome to another edition of Fire Law Roundup.
Let's end today. This is going to be a great discussion. I don't know if you want to do the facts, you want me to do it, but let's go to Boston.
I'll do it. I'll do it. I'll do it. Only because I've been following this case now since 2018, and I have some sympathy for the firefighter involved, but I also am very familiar with the law, and I just don't see how he gets himself out of this situation. But we got an African American firefighter who's also the vice president of the Boston Firefighter Vulcan Society, which is an organization of African American or minority firefighters in Boston. And he apparently was turned in for an inappropriate post. There was something that he posted, which the reason I say that it's interesting because the original post that he was reported, I think, is protected by the First Amendment. It was a post, it had to do with Nat Turner's slave rebellion. And again, he's the vice president of the Vulcan Society. And, arguably it was offensive, but I think all in all, I think it was probably close. It was a close call. Depends on what the judge is going to say, which is my beef with Pickering.
Right.
Okay. But at any rate,
we'll get there.
But that's what starts the investigation. Once the investigation gets going, though, they find this whole mess of just really horrific offensive posts. And I don't want to get into it. I've got you. If you want to go back on my blog, you can go read all the things.
Racially charged. Yeah,
racially and homophobic and misogynistic and a whole bunch of others. So,
not the light you would want a member of your department depicted, right? To build the public trust. And I say that for a reason.
Right. And I think part of his defense is that, hey, you started investigating me for something that's protected. And then it was only because of that you found these other things. But at the end of the day, you still posted those things. And even though they were posted as a private citizen, they weren't posted as a member of the Boston Fire Department. They were just so offensive that the department terminated him. And he challenged it through the mass civil service system. And in I think a very well-reasoned decision, the Civil Service Commission upheld his termination. And I've got a link to that in there. And they did a pretty good job for not being a federal court and dealing with a difficult First Amendment issue. And certainly they are attorneys. But they did a pretty good job of addressing the First Amendment issue. Then it got into court, and we had a Superior Court decision, which essentially did a pretty good job of agreeing with the Civil Service Commission's analysis. And now we're at the Massachusetts Court of Appeals. And the Court of Appeals essentially did a very good overview of the First Amendment and concurred with both the Civil Service Commission and the trial court that we can't have public employees who are, it's not that you're expressing, it's not that it's your speech, it's that you believe these things. It's inconsistent with your willingness and ability to provide a service to everyone in the community. If you harbor this much animosity toward other people, you're not an appropriate fit to work in a public position. And I think that's at the heart of it. So yes, it is a free speech issue, certainly, but it goes beyond that. And the reason I say that is that's why, even though he did it as a private citizen, and it's certainly race relations and gender and all that certainly are matters of public concern.
Right. Everyone agreed to the first two parts. Right.
Right. But it can cause actual harm or disruption to the mission and function of your employer. We can't have Nazis. Right. We can't have Nazis being firefighters or police officers. We can't. Do you have a First Amendment right to be a Nazi? Absolutely. Absolutely. Okay. But we can't have someone who harbors that kind of hatred toward others working in a public capacity.
And, look, I'm Jewish, right? So right off the bat, I don't think we should have Nazis in the public service. But
you would defend if a Nazi came to you and was being unfairly targeted, you would defend them. you know, and I'm
Yeah,
not a
probably
fan of
wouldn't.
Nazis. Okay, well, maybe you, maybe, I
Especially
mean,
Illinois Nazis.
Al-
I mean,
Alan Dershowitz would. He has said that
Alan Dersh.
repeatedly. You
I
know
was
what I'm
just about
saying?
to quote him.
And that you say, despite the fact I vehemently disagree with you, I will defend you.
Because, add the because, what Alan Dershowitz says, because if you believe the Constitution, you
That's right.
have to defend every part of the Constitution. If anyone hasn't read his book for the last 20, 30 years, unfortunately, his defenses of Trump have skewed his credibility a little bit. But he's a brilliant man, a Harvard professor. But
absolutely.
Alan Dershowitz rightly says, if you are going to be a defender of the Constitution, you defend it when it makes you sick.
Right.
Now, here's my problem. Right? Yes, the whole Nazi thing obviously makes me sick. Right now we have the whole Hamas, Palestine, Israeli, right? So it's a very tough time, and there are feelings that are being shared. But here's my problem. If I said to you, I don't like Jews because they're money hungry, whatever. Okay, so I don't like Jews. And by the way, anyone quoting this, I'm Jewish. This is not like this is an example. However, does that mean that I'm not going to risk my life to rescue you? It doesn't. And that's my problem with this, is because I spew an ideology that may harm my fire department's perception in the public. And I'm going to give you a very real example on top of this. That doesn't mean that I shouldn't have the right to say certain things. Now, hateful, bullying, certain speech is not speech at all, the U.S. Supreme Court said. So it's not protected because it's not speech. And a lot of this hateful, racist speech isn't even defined as speech, right? Says U.S. Supreme Court. The problem here is when you're speaking on an issue that you believe in and the public may not like it, does that mean that you don't trust the public? So let's get a very real one here. Black Lives Matter and the Confederate flag, right, are two big issues where, and I get it, the African-American community probably wouldn't trust a fire department with a Confederate flag on it, right? Probably wouldn't. But that's not hate speech because it's not used to intimidate, says the U.S. Supreme Court. Hate speech is speech that's used to intimidate. It's not just a symbol. And so the problem is if I spew an ideology, I don't like Black Lives Matter organization because I don't trust their money, maybe you say, or, you know, how they handle the money, right? Or I don't like Trump because he spews whatever ideology. But it's still, you have the right to support or not support those organizations and speak about them. And just because the public may find that distasteful, does that unprotect your speech? Well, that's my problem with some of this.
I get it. And that's, I think this is Octavius Rowe's argument. I think that's the crux of his argument. The other side of it is, and the way the Supreme Court has interpreted it, is when you engage in speech that can cause actual harm or disruption to the mission and functions of the fire department. So now, so you have this right to have this thought, absolutely. But the fire department's got to show that it disrupts the mission. And the way that they do that is if, for example, if I don't know what's a better example, but let's use the Nazi that you know, the Nazi. Sure. If I am Jewish and somebody gets sick in my house or my house catches fire, I'm going to be saying, do I want to call 911 and have the Nazis come? You know, and take a risk that one of those Nazi firefighters is going to come, because then he's going to know I live here, and maybe he won't do anything while he's here, but maybe he'll come back and get me at a later date, or I don't even want to take a chance. I'm going to try to deal with the problem myself. And in that way, it interferes with the mission and function of the fire department, because, and they've said that in several of the decisions in this line of cases, is that the public, when they call 911, should be free to expect that the people who are going to come to help them are not going to harbor these kinds of hatred directed at them. And that we don't want people hesitating to call. Okay, same thing with the Confederate flag. And while on one side, I understand the symbolism for the South and folks, you know, it's a symbolism for white folks in the South of their ancestry and all that. But On the other hand, if you have Confederate flags hanging off the back of a fire truck, African Americans would be like, I don't want them coming to my house. And that's understandable. It interferes with the mission and function of the fire department. And that's the line. And is it a comfortable line? It's not a comfortable line. It's
a
not
blurry line.
It's a difficult line. Okay.
Yeah.
But again, just for our listeners, just to understand the Pickering decision, number one, it's got to be a matter of public concern. In order to have First Amendment protection, got to be a matter of public concern. You've got to do it as a private citizen. If you're in your uniform, if you're on duty, if you're doing it in a way that you're perceived as not doing it as a private citizen, you're not going to have protection. Matter of public concern as a private citizen, and then it can't cause actual harm and disruption to the mission and functions of the fire department. And we've got this balancing test that actual harm or disruption is actually part of that balancing test that the courts have to look at.
And it's a very tough line. Like the balancing test also been used as like internal disruption, right? It causes disharmony and extreme disruption within the organization.
Right. So it's inside internal disruption, but also out external. So it's both of them. Yeah.
And I think it could be either or, right? I mean, if it either or both. And so in this case, sure, if somebody was and I was in the department, someone saying, "Oh, we don't want a Jew as a chief," right? Yeah. Well, that is language that, right, is A, not a matter of public concern, but B, it's disharmony, it's disruptive. The problem with that type of, and this is your issue, the problem with that type of balancing test, right, rights to free speech versus the effect and the disruption such a hard to define, right? So, 20% of our people are Jewish, and so they're pissed off. 80% of our community is Jewish, so they're pissed off. Or, now nobody gets along. Or, what is the amount of disruption necessary in the public or internal to cross the line?
Well, and that's where the judge's own personal bias can cause them to see disruption. You have one judge that on the same fact sees disruption. Another judge would say that's not disruption.
Right.
And there's an awful lot of discretion that a judge has in that. And the judges would say, oh, no, we don't have any discretion. You've got discretion. Okay. There's inevitably you're balancing. And that, you and I, before we came on, you and I talked briefly about some of the differences that I have with our friend Chip Comstock, who I have the utmost respect for. Chip thinks the Pickering balancing test is a pretty good one. My reservation is that it gives judges too much discretion, and their personal bias, one way or the other, can cause a case to go. And we see that where a trial court says you're not protected, the intermediate appellate court says you are protected, and the Supreme Court says you're not. And the fact that you're going back and forth here means that we're in the weeds here when it comes to discretion.
Which is why my advice usually to my clients is, do you really want to go down that road? The problem here is, now you have such a vocal, right, person that is, if you do nothing, it's going to make it look like you did nothing. Even if they lost the lawsuit, right? Even if the municipality is deemed, the fire department's deemed, okay, violated his First Amendment rights, I don't think it mattered. I think this was a lose-lose situation. If you didn't go after it, then in the public's eyes, you were tolerating it. And let the public be mad here at the court system if they had held it wasn't protected, right? Here it turned out to be a win for the fire department. But I don't think the fire department had a choice. But normally my advice to my clients is, and I'm a pretty aggressive lawyer when it comes to litigating, and but normally I'm suggesting, look, is it worth 5 years of a fight, which has a 50-50 flip of a coin chance at winning, to fight free speech issues, or is it worth just letting it go, right? Yeah. And grow a thick skin? Here, your community can't grow a thick skin when they're watching a firefighter do this. Different issue, but still, these are tough to win, and they're tough to predict, right? Yeah. As you said, you can't predict it.
Right. Yeah, it is. I mean, I equate it to I've played baseball most of my life, and I've managed a lot of teams, coached and managed a lot of teams, and you're down a run, and you got to run around first base. Do you have him steal? Do you not have him steal? You're not going to know whether he's going to be out or safe until he gets to second base. You can have a guess that I got a fast runner, I got a catcher with a bad arm, maybe we got a good chance, but that's what you're dealing with here when it comes to posts on social media. Are you going to be out? You're going to be safe? I don't know. We'll see what the umpire says when you get to second base.
Right. I'll let you know you're brilliant if you were right.
Yeah,
right?
There you go.
If
So,
no different. Should we go for the 2 point, right, or just just take the normal PAT, or should we go for 2 points and try to win it right here? You don't know, right? So, but I got to tell you, and I open this way, I'll close this way. These cases are great cases for so many different reasons, but all of them help expose issues that how the public will view you, whether it's the bullying, whether it's the drugs on the fire scene, whether it's the racist, homophobic comments, right? Whether it's all of these cases, whether it's the theft or misuse of public funds, all of these cases I found so exciting, and thank everyone for watching to the end, because it's all about how the public's going to view us. Right. And what we need to do to protect our image, because if we don't protect our image, then these are the images that are going to be seen. And it's going to result in loss of funding, loss of trust, loss of people wanting to work in your location. Right. People aren't going to come to work there if it's a bullying, harassing, whatever environment. These things aren't good for us. So all of these cases had one theme, which I thought was so interesting: public trust.